Hi, this is Lawyer Dan, also known as Dan Smith of DPS Legal Counsel, and the host of the podcast Legal Scrubs, where I take a business law issue, a problem that may crop up for your small business or your healthcare professional practice. I analyze it, I diagnose the problem, and I provide a possible treatment option for your business. And so if you haven't started listening to Legal Scrubs podcast yet, I invite you to go where you find your favorite podcast, iTunes, wherever, and check for Legal Scrubs and subscribe. And today's episode of Legal Scrubs is going to focus on what are the four main categories of intellectual property that a small business can have. How long do they last? And what's the best thing you can do to protect them? Intellectual property is one of the most valuable assets that a lot of businesses have. And if you're just starting out in your business, you want to make sure that you protect your intellectual property. So what are the four major types of intellectual property? And how long do they last? And how do you protect them? First, trade secrets. Trade secrets are essentially a whole compilation of information that is a secret, not generally known to the public, that provides economic benefit to your business because it is a secret. For example, the most famous example of a trade secret is the recipe for Coca-Cola. And so it's a trade secret because it has great economic benefit to the company because it is a secret. It is, and so it's the perfect example of what is a trade secret. So if you have a business, you're going to have certain confidential, secretive, proprietary information that you don't want out in the public domain. Those are, and if you get value because that information remains secret, then that is a trade secret. Trade secrets are a protectable and protected class of intellectual property, and the way you protect it is essentially taking all reasonable steps to keep the information private, keep it secret. If you have a company that has where employees or workers have access to information, you want to restrict the information, access to the information that are trade secrets on a need-to-know basis to your workers, and have workers sign good confidentiality agreements. You don't want to put your secret information anywhere out there in the public domain. That's how you protect your trade secrets. Trade secret protection essentially can last forever as long as you keep your trade secrets secret. For example, again, the recipe for Coca-Cola. Coca-Cola has been around for a long, long time, and that recipe remains a protected trade secret. Trade secrets are somewhat different from other types of intellectual property in that rather than filing an application, putting information out there on the public domain like with trademarks and patents, you do exactly the opposite with a trade secret. You keep it secret. You don't tell people. You keep it secret, and that's how you protect it. And essentially, like I said, trade secret protection can last forever as long as you keep the secret a secret. So that's number one. Number two, the second type of intellectual property a business can have are patents. Patents essentially protect discoveries and inventions, really inventions. And so the way that you get protection for patents, patent protection, is to file a patent application with the U.S. Patent and Trademark Office, or the USPTO. If you get a patent, registered patent for your invention, whether it's a design patent or a utility patent, you're going to have protection for your patent for a limited number of years. I believe it's 15 years for a design patent, 20 years for a utility patent, but there is a limitation on the length of time that a patent can be protected. But the way you protect your patents is you file a patent application with the USPTO and you get a registered patent from the USPTO. The third type of intellectual property that a business could have are trademarks. Trademarks are essentially words, designs, or a combination of words and designs that identify the source of a business's goods and services. For example, if you see the Apple logo that looks like a half-bitten part of an apple out of it, you know that that's the logo or the trademark for Apple Computer. If you see the little swoosh sign, you know that that's a trademark for Nike. You can have certain words as well, like Xerox, all kinds of any business you can think of that has trademarked its name and its certain words in connection with its business can be trademarks. Now, how do you get trademark protection? Trademark protection really in the United States arises from first use. So if you actually use a trademark, even if you don't file for a trademark registration, if you can prove that you were the first to use it and are continuing to use it, that's where your actual protection comes from. It comes from use. Now, you still will want to register your trademarks because it provides notice to the world that you are the registered trademark owner, and it provides certain other benefits in the event someone tries to infringe on your trademarks. Trademarks basically can last forever too, since they arise from first use. As long as you're using them, technically you have that trademark protection forever. And then even with registered trademarks, as long as you continue to renew them on schedule, typically every 5 years, there's a renewal registration that's required at different intervals of time. But first one is usually due after 5 years. As long as you renew it over the course of time, your federal trademark registration can stay in effect essentially forever. So that's trademarks. Now, the fourth type and final type of intellectual property are copyrights. Copyrights protect the tangible production of original works of authorship. So if you write a novel or you write a song or you create software, you have created something brand new. You have a work of authorship that has been reduced to tangible form, and you have a copyright. Copyright is similar to trademarks, where trademarks originate on first use. Copyrights originate upon the production, the authorship of that copyrighted material. And so you can still register your copyright, and in a lot of cases you will want to register copyrights. Similar to trademarks, if you register them with the Copyright Office, it provides a proof of publication, a proof of ownership through a national database. And it also provides certain benefits in the event of copyright infringement. You know, there was a recent case in the news dealing with music and a song with a famous performer and maybe a couple of performers, and we won't go into that here, but that was a case that involved the doctrine of copyright and the doctrine of copyright infringement. And you can see that there is some great value in the ownership of copyrights. And so those are the four essential, the how long do copyrights last? I want to mention that. If you are an individual person who creates a copyrighted work, such as a novel or a song or something like that, then the copyright basically lasts for your lifetime plus 70 years. If you produce a work that's either anonymous, or it's done under a pseudonym, or it's produced as a work for hire, then the copyright lasts for 95 years from creation, or 120 years from first publication. I'm sorry, I have that reversed. 95 years from publication, 120 years from creation, whichever is less. And so there are limits on copyrighted material. There are limits on patented material. Essentially, there are no limits necessarily on trademarks. Particularly if you have a registered trademark and you continue to renew it with the USPTO, and with trade secrets, as long as you keep it secret, it can last forever. I hope that helps. I hope you've learned something about the four major classes of intellectual property, how they're created, how long they last, and what you can do to protect them if you are a small business that has intellectual property. All right, that's it for today. Watch next time for another episode of Legal Scrubs, and we'll see you then. Thanks.